I disconnected it. 1 second. You won't have your clicker for a second.
Okay. So good morning, everybody. Thank you for coming to Triple J Symposium. As Mike mentioned, my name is Jordan Garsson, and today I'm going to be discussing the Estoppel effects that are associated with real parties in interest, or RPIs, in inter parte review. So that's IPR. There are a lot of acronyms in this, so just try and follow along with me. But this presentation is going to consist of 6 parts. So first, I'm going to give you some background on why we have IPRs. And then second, I'm going to look at the current standards that are associated with these proceedings. Third, we're going to look at what a real party in interest, or RPI, actually is and how to identify one. Then fourth, we're going to look at the RPI requirements, harm to petitioners. And fifth, turn to how that harm has been shifted to patent owners through the practice of hiding real parties in interest. And sixth and finally, we're going to look to see whether there should be any reform to our current RPI requirement. So looking at some background on RPIs. After the creation of new administrative trial proceedings by the AIA, the PTAB has been a busy patent litigation venue. In fact, there were over 12,000 petitions for AIA trials since it's been started, and over 90% of those have been filed for IPR proceedings. So IPRs allow for the correction of a patent regardless of whether there is a case or controversy at issue. So an IPR permits the review of prior art for invalidation purposes without expounding on further legal or technical questions. And although the AIA established the current IPR proceeding, this review process isn't an entirely new framework because IPR proceedings arose as a revision and as a replacement of a previous inter parte reexamination, or IPX, process. And there were major areas of complaint that were associated with these IPX proceedings. They had no durational limitations and would last for an average of 3.5 years. And they also couldn't be brought against any and all issued patents. So IPRs were established as a direct response to these concerns, with Congress explicitly stating that these proceedings were intended to provide a quick and cost-effective alternative to litigation. So IPRs are widely considered to be a popular form of post-grant review, and they're markedly more utilized than their predecessor. And this is because all patents are eligible for this kind of review, and any person other than the patent owner may request an IPR. Additionally, IPRs are statutorily mandated to have a within 1 year duration between the start of the review and the PTAB's determination. So IPR proceedings involve an argument between a petitioner, so that's the person who's challenging the validity of the issued patent, and the patentee, who's the owner of that challenged patent. And since IPRs are purposely designed to be low cost and efficient methods for challenging validity, there's a limited form of discovery that's typically used in these. So typically discovery for an IPR proceeding includes deposition of key witnesses and experts that have submitted sworn affidavits, but not much more. But to get to an IPR proceeding, the petitioner has to first file an IPR petition. And so since this process is fairly petitioner friendly, there are 2 key limitations on IPR petitions that are meant to kind of serve as a balance of power. And these are a time bar limitation and an RPI requirement. So the RPI requirement says that all real parties in interest have to be named in the petition for IPR. And the main portion of the time bar limitation that's relevant to our discussion today states that a petition for IPR has to be filed within 1 year of the person being served with a complaint alleging infringement of the patent, or the entire petition is barred. So the strict time limitations apply not only to petitioners, but to all named parties, which encompass real parties in interest. So due to the impact on the time bar limitation and estoppel provisions that can arise from an IPR proceeding, the RPI requirement is a pivotal component of the petition. And this connection between the RPI requirement and the time bar limitation protect a patentee from copious amounts of challenges by its competitors. And the primary reason to apply the estoppel to RPI following an IPR determination is that it prevents petitioners from having multiple attempts to invalidate a patent on the basis of the same prior art. So looking to what a real party in interest actually is, the statutes that pertain to IPRs don't provide any explicit definition. All that's statutorily mandated is that a petition has to identify all real parties and interests. And there isn't any legislative history, case law, or guidance that offer an instruction on the exact test for determining a real party and interest. So looking back to what real parties and interests are generally, the idea of RPIs predates the statute. It's a term that's originated in English common law. And common law judges recognized that beyond a party who's involved in the legal proceedings, there could be other parties that are benefiting and have an interest in a proceeding. So the root of what constitutes an RPI is a party that benefits in some way, even if they're an entity that's different than the petitioner. And a modern understanding of an RPI is somebody that has a material interest in the lawsuit. But simply saying that there's a material interest in the lawsuit isn't enough for somebody to rise to an RPI in an IPR proceeding. So in the absence of any hard and fast rules providing a bright line test for when a party needs to be considered a real party in interest, the PTAB has instructed that this is a highly fact-specific inquiry that needs to be conducted on a case-by-case basis. But there is some guidance that's been provided by the Supreme Court's Taylor decision in 2008 that articulated a factor-based approach for when an entity may be considered a real party in interest. So getting some context and looking into the Taylor decision, the court was tasked with determining whether Estoppel principles applied to a party that was not named in litigation. So this all began when there was a plane owner and pilot who decided that he wanted to sue the Federal Aviation Administration, or the FAA. So he filed a complaint and brought suit in district court against the FAA, and he lost pretty abysmally badly. And in the court's decision, they articulated to him all of the good arguments that he could have brought and that might have been successful, but that he ultimately just didn't raise in his complaint. And so Herrick, having lost this, immediately went to his friend Brent Taylor, who was another plane owner, and asked him to file a complaint against the FAA, including those arguments that were mentioned by the court. And so Taylor filed a near identical complaint and had the same representation that Herrick had, was funded by Herrick, and ultimately brought this case back to the court where he was successful against the FAA at the district court level. But the FAA ended up appealing this, saying that Taylor should not have been able to bring this suit in the first place because he was funded by Herrick and because Herrick was a real party in interest and that he needed to be stopped from making these arguments. And the DC Circuit agreed with that and said that Taylor should be precluded, but the Supreme Court unanimously held that Taylor was not virtually represented in Herrick's earlier litigation, and that it needed to be a real rarity when we consider a party to be a real party in interest. And so in Taylor, in Justice Ginsburg's opinion for the majority, she stated that there are a variety of exceptions for when somebody should be treated as a real party in interest. And particularly, she noted 6 different exceptions that have now turned into a factor-based test that is used around the courts today. Now, in the context of IPRs and PTAB Federal Circuit case law, the Taylor decision is looked at in a specific fashion, looking at this 4th factor of a non-party assuming control over the litigation. That's been given determinative weight for identifying RPIs in a variety of IPR petitions. And so they're looking directly to see if there is some financial control that's being exerted by an unnamed party. So now that we've got an understanding of what an IPR is and a rough understanding of how to find an RPI, let's look to what can happen from a failure to name an RPI in an IPR petition and how that's affected petitioners and subsequently patent owners. So based on the severe harm for a failure to name a real party in interest, it seems that the RPI requirement should be a large portion of your petition. But in actuality, an IPR petition can be up to 60 pages, and that page limitation doesn't even include the required sections like your title page, your table of contents. It doesn't include required sections for standing, and it often doesn't include your exhibits. Additionally, important for our conversation, it doesn't include the mention of the real party in interest, which is that little box right there. Usually this is just a sentence-long section that names the specific parties that have an interest in the case, and forgetting to name even one party will be enough to have your petition denied. And the statutory language explicitly forbids consideration of an IPR petition that does not identify all of the real parties in interest. And further, if the PTAB concludes that a petitioner has failed to name a real party in interest after the proceedings have been initiated, the proceedings are terminated, estoppel provisions can still apply, and the petitioner cannot recover any of the costs that have already been spent on litigation. So while the petitioner can make a request to update their IPR to amend the section that lists RPIs so that they can include the unnamed party, this determination is subject to the discretion of the director. And to make matters more complicated, the position has been at odds with some of the USPTO's reports to Congress. There have been reports that have noted that errors in identifying real parties in interest can sometimes occur without any deceptive intent and currently are not correctable. And that same message remarks that a statutory change is necessary to avoid situations where the petitions must be denied despite a good faith error. So many petitioners are unaware of the possibility to amend the section that identifies RPIs, or they might face a direct inability to do so. So petitioners are often subject to their entire petition being denied, a termination of their proceeding, or a prohibition of continued action. And this can amplify the negative effects of acquired estoppel. So beyond the time bar, statutory IPR estoppel applies after a proceeding, and it bars any ground that the petitioner and the RPIs raised or reasonably could have raised during that IPR proceeding from being re-litigated. But the exact scope of the statutory language has been shaped by case law. So in 2016, the Federal Circuit issued an opinion setting forth the rule for what grounds an RPI or anybody involved in the proceeding is stopped from litigating after the proceeding is over. So in Shaw, the Federal Circuit explicitly stated that the only grounds that would be stopped following a proceeding were those that were raised by the petitioner and then instituted for review by the PTAB. So a denied petition or grounds that weren't raised by the petitioner were not stopped. And so this allowed for a real party in interest to be party to a later challenge of validity, even for the same prior art, so long as those grounds hadn't been instituted in front of the PTAB in an earlier proceeding. But there was a split within the district courts that arose almost immediately after Shaw regarding grounds that were not raised by the petition, but could have been raised, and whether those were stopped. So 2 years after this confusion began, the Supreme Court weighed in and attempted to provide guidance through the decision in SAS. And while the decision here didn't directly address IPR estoppel provisions, the Supreme Court's holding clarified that the PTAB has to review all grounds raised by a petitioner when the USPTO allows a petition for IPR to develop into a proceeding. And so since it required that there were no longer partially instituted IPR proceedings, the consensus became that statutory estoppel covered all challenges for raised petition grounds and all reasonably could have been raised non-petition grounds. So by allowing IPR estoppel to apply to all petition and non-petition grounds, the principles of acquired estoppel were greatly broadened. So the effects of this broadening and the repercussions that can come from it are illustrated by the Caltech v. Broadcom case, which was decided by a district court in 2020, and recently, last February 4th, it was decided by the Federal Circuit. So in 2016, Caltech filed suit against Broadcom and a variety of other companies, including Apple. Apple acted very proactively and immediately filed for an IPR proceeding through its IPR petition. And it was ultimately unsuccessful in invalidating any of Caltech's patents. But later, Broadcom raised the contention that it could successfully assert some prior art that would invalidate Caltech's patents, but they were ultimately stopped from making claims against the validity because Apple was a real party in interest to their suit at the district court. And so because they were stopped from making these arguments, Broadcom was left in a position where it was unable to challenge the validity of Caltech's patents. And so the only arguments that were permitted in front of the jury at the district court were those that assessed Broadcom's potentially infringing activity and the damages that could be awarded to Caltech. So the jury at the district court level returned a judgment for $1.1 billion in damages against Broadcom. And when the Federal Circuit recently reviewed this case, they did vacate the $1.1 billion damages, but they took the opportunity to affirm the reasoning on the estoppel that was used by the Central District of California, and they explicitly overruled the prior case law of Shaw, leaving us with just that SAS reasoning as to both petition and non-petition grounds are subject to estoppel. So this leaves severe estoppel consequences for petitioners. And in an effort to avoid these, the practice of hiding real parties and interest has exploded. So because the PTAB focuses their inquiry for finding a real party and interest on whether the unnamed party has exerted sufficient control over the petition and the litigation, if an unnamed person is not directly funding the litigation or participating in that litigation, then the RPI can be effectively hidden. And so by circumventing the RPI requirement, the petitioner is able to test litigation strategies during an IPR proceeding without that fear surrounding an IPR estoppel repercussion. So IPR litigation and this practice specifically have given birth to a new type of entity, the reverse patent troll. So this name is derived from the idea of a patent troll, which is a term in patent law that refers to a non-practicing entity that seeks to enforce patents for monetary gain. And this is the exact flip side of that. So a reverse patent troll is a non-practicing entity that is seeking to invalidate a patent for some type of monetary gain. So typically in the scope of IPR proceedings, a reverse patent troll is a company that files an IPR petition on behalf of one of its interested clients, but it obfuscates who that client is. And so would-be petitioners are increasingly turning to these reverse patent trolls for assistance in the IPR process. And by somehow indirectly funding the reverse patent troll, the unnamed client is able to remain hidden. And so after this, a variety of companies have made millions and gained notoriety purely through their work at filing IPRs to the benefit of their clients who remain unnamed. And while a patentee can assert that an unnamed party should be listed as a real party in interest to the proceeding, the petitioner's initial identification of RPIs is presumed to be correct. And so it's accepted that all of the parties that are named within the IPR petition are all of the interested parties unless the patentee can prove otherwise, placing the burden on them. So this has shifted the burden and the harm to the patentee in an IPR proceeding as a means to avoid this type of acquired estoppel. And this is even though the RPI requirement is meant to be a protective measure for a patentee, and it's now being used against them. So when petitioners evade the RPI requirement and in turn remove this idea of a time bar limitation or any estoppel repercussions, the petitioners are effectively given a second bite at the apple. And they're allowed to reap the benefits of an IPR without any sort of downside. So this heavily tilts the scales against the patentee in an IPR proceeding. And so because of this, patentees now are unable to evaluate all their options. They can't find previous suits that were brought by interested parties, and they can't quickly present optimal defenses that worked against those interested parties in the past. So perhaps unsurprisingly, over 2/3 of IPR petitions end up being brought by defendants in patent infringement suits in the district courts. So due to the large benefit that comes from succeeding in an IPR proceeding, a single patent can often be subject to multiple IPR petitions. And the patentee that's involved in an IPR proceeding rarely comes out unscathed, because less than a quarter of IPRs have resulted in none of the claims of the patents being invalidated. So it's really of vital importance that we're able to ensure that the occurrence of invalidation isn't increased through some sort of manipulation of the IPR petition, such as the omission or the avoidance of naming RPIs. But ultimately, this harm hasn't gone unnoticed by the Federal Circuit. So after observing the harms imposed by the on the patentees by hidden real parties and interests, the Federal Circuit attempted to make a new method for determining RPIs in 2018. And that was through the case of Applications in Internet Time v. RPX Corporation, and this is commonly known as the AIT decision. So the relevant patent litigation for this issue began in 2013, where AIT brought suit against a company called Salesforce. And this suit was filed with the claim that Salesforce was infringing upon 2 of AIT's patents. And when Salesforce first heard this, they filed a petition for a different type of post-grant review. They're called Covered Business Method Patent Reviews, or CBM reviews. And they filed those petitions against the 2 patents that were raised against them. But the PTAB ultimately concluded that these patents by AIT did not fall within covered business method patents, and so they denied the petitions that were filed by Salesforce. But shortly following the denial, Salesforce realized that it actually had prior art that it was able to assert against AIT to invalidate its patents. But Salesforce also realized that it was facing a huge problem. They chose to pursue a different type of post-grant review, and they had waited over a year since they were informed of their potentially infringing activity. So that time bar limitation was stopping them and prohibiting them from filing an IPR petition to assert this prior art. So Salesforce turned to RPX, which is a successful reverse patent troll, to help them with their IPR petition. So in 2015, RPX filed 2 IPR petitions, and each challenged the validity of one of the AIT patents that was asserted against Salesforce. And they based these petitions on the prior art references that Salesforce had in its own company records. And so RPX engaged in one of the most commonly practiced forms of hiding their RPIs. They shielded their client by having Salesforce pay indirectly for the litigation, and they were able to have their client avoid any estoppel or time bar effects. And when AIT asserted that Salesforce was clearly an unnamed RPI, they were using their prior art references, and there was this ongoing litigation between AIT and Salesforce. The PTAB ultimately used the test looking for control and found that Salesforce was not a real party in interest because there was the lack of a direct payment or financing of these proceedings for petition. So the PTAB determined that not only was Salesforce not a real party in interest, but that the prior art did invalidate all of the claims of AIT's patents. So AIT immediately appealed the decision of the PTAB to the Federal Circuit, and this led to the Federal Circuit's AIT decision in 2018. The Federal Circuit chose to vacate the decision of the PTAB, and they remanded this case along with a new standard for determining a real party in interest. So it seemed like the Federal Circuit was articulating a new functional approach to determining whether an unnamed party was actually a real party in interest. And in Judge O'Malley's opinion for the majority, she expressed that a determination of a real party in interest demands a flexible approach that takes into account equitable and practical considerations with an eye toward determining whether a non-party is a clear beneficiary that has a pre-existing and established relationship with a petitioner. But even as early as the remanded AIT case, there were signs that the Federal Circuit's decision was not going to change the typical practice. So the PTAB reviewed the facts of this case. They looked at the business model of RPX, and they looked at the relationship between RPX and Salesforce. But the final determination rested heavily on the financial backing that Salesforce was providing to RPX. The PTAB expressly stated that critically, Salesforce paid RPX in order to reduce Salesforce's patent litigation exposure. And by finding records that they had paid them for some sort of reduction in harm from litigation, they found that that showed a direct financial control. So the decision was ultimately still resting on this analysis and determination of financial control over the proceeding. So because the only use of the framework was implemented to determine control, which can be hidden through different types of restructuring, and a common practice now is to separate businesses to a law section and a business section and have your interested parties be purely clients of the business side and not connected to your legal branch. RPIs are consistently still being hidden. And so the control, in a remarkably similar fashion to how it was determined before, is still operating in the same way within the PTAB. But the current tests for RPI and the strict repercussions of acquired estoppel have led to amplified harms on both sides of the V here. Petitioners are engaging in costly and time-consuming and borderline unethical behavior to keep RPIs away from having direct control over a proceeding. And patentees are having to engage in costly discovery that ultimately turns out to be unfruitful because of its limitations. And at the same time, all of these unnamed parties are still being shielded. So the current RPI requirement is eliminating the cost-effective and efficient benefits that an IPR is meant to provide. But looking forward, the current troubles that are surrounding the RPI requirement could be solved through reform in the area. So when approaching reform, the first question to consider is whether IPR petitions should even have an explicit requirement to include and name real parties and interests. But without the RPI requirement, a patentee would be subject to unjustifiably difficult challenges, and there is concern that it would turn the PTAB into a death squad, killing property rights. And based on that severe critique, it seems like the RPI requirement is important to maintain within this system. But if it's a requirement that needs to stay, the next consideration is how should a party be deemed an RPI? And the solution can come from what's already attempted to be in place by taking a functional, factor-based framework and looking at all 6 of the Taylor factors when determining whether a party actually amounts to a real party in interest. But ultimately, the main consideration here is that repercussions for failure to name an RPI cause many harms associated with petitioners and patentees because of the strictness of those repercussions. And as the current requirements stand, a failure to name one real party in interest can result in the entire denial of a petition. And so rather than simply allowing a minimally used exception for amending a petition to name an RPI, reform could involve having the statute explicitly allow the petitioner to amend the IPR petition as a matter of first recourse, so that petitioners know that this is an option available to them. But as we continue seeing the rise of IPR litigation and the corresponding rise of hidden real parties and interest, these reform options should be at the forefront of our minds. And I see that I am right out of time, but I will be at the symposium all afternoon if anybody wants to talk about questions.